Chapter 14, Issue a patent. Issue a patent, issue a patent, assignee, how issued, content of the term of the patent, provisional rights, pre-American Inventors Act, contents, term of the patent, provisional rights, repeal the period, extension of the patent term, pre-American Inventor Act, statutory invention, registration. Alright, Title 35 U.S. Standard Code 151, issue of the patent. General of the period of the application of the title of the patent, under the law, the written notice allowing for the application shall be given the mail with the applicant with the notice shall specify with the sum of the constitute issuing fee required for the publication fee shall be paid within 3 months after the effect of the payment. Upon payment, the sum of the patent may issue the payment and not timely made with the application shall be regarded as abandoned. Title 35 U.S. Standard Code 152, issue the patent. Assignee, the patent may be granted with the assignee of the inventor of the record, patent, and trademark offered upon an application made with the specifications form of the inventor, except as otherwise provided in this title. Title 35 U.S. Standard Code 153, how issued patent shall be issued with the name of the United States of America under the seal of the patent trademark office shall be the time of the director of the signature played with thereon shall be recorded with the patent trademark office. Title 35 U.S. Standard Code 154, content of the term of the payment of the provisional patent rights. General of the contents of the patent shall claim in the short with the invention of the grant of the patent due to his or heirs or sign of the right to exclude with the others to the making, using, offer, sale, of the selling an invention throughout the United States, with the importing an invention of the United States, ever the invention profit the right to exclude with the others from the issue of the offering, sale, of the selling throughout the United States, importing United States products may be made with the process referring to specification particular thereof, the term subject of the payment of the fees, the name of the such of the grant of the term beginning on the day of the patent issue, the ending 20 years for the day of the application of the patent was filed with the United States of the application contained with a special reference no earlier to an earlier file of the application under section 120, 121, 365C, or 386C, with the date of the earliest such application was filed. Priority under section 119, 365A, 365B, 386B, A, or 386B shall not be taken into account when determining the term of the patent. Specification drawn on the copy of the specification drawn should be the ending of the patent, shall be part of the such patent, adjustment of the patent term of guarantees, guarantee of the profit of the payment, the trademark offer the response, subject to the limitation on paragraph 2 of the issue of the original patent, with the delay due to the failure of the patent trademark offer the 2 with the 1 provide at least 1 notification under section 132 with the notice allowance of section 151 no later than 14 months after the day of which the application was filed under section 111A, or 2 with the date of the commencement of the national strategy under 371 with the international application. 2 with the respondent reply with the section under section 132 with the appeal with the taken under section 134 within 4 months after the date with which reply with the file with the application appeal that was taken. 3 an applicant with a 4-month period with the date of the decision patent and trial of the appeal board under section 134, 135 of the decision federal court under section 141, 145, or 146 in the case which allowable claims remain in the application, or 4 issue the patent with 4 months after the date of which the issue fee was paid within section 151. All of the outstanding requirements was satisfied. Term of the patent shall extend with 1 day each day after the end of the period specified by the clause 1, 2, 3, 4, as in the case of the initial until the action described in such clause is taken. Be a guarantee no more than 3-year applicant and pendency. Such the limitation under paragraph 2 of the issue with the original patent delay with the failure under patent trademark offer the issue of the patent 3 years after the actual filing date of the application, section 111A of the United States, in case of the internal national application of the data commenced from the national state during section 371 with internal applications not included at any time of the consumer to continue with the examination application required for the application under section 132B. Anytime consumed with the proceeding under section 135A, the time consumed with the imposition order of the under section 181, the time consumed with the appealated review, patent trial, appeal board of the federal court, or any delay with the proceeding of the application in the United States Post Patent Trademark Office, the requested applicant expectedly permitted in paragraph 3C. Alright, the term of the patent shall be extended with 1 day each of the day after the end of the 3-year period when the patent is issued. Guarantee the adjustment for the delay due to the derivation proceeding with the secrecy or with the appeal with the limitation on paragraph due to the issue of the original patent is delayed due to the proceeding under section 135A, imposition under section 181A, 181 or 3, appealated review of the patent trial of the board of the federal court and gave the patent issue with the decision reviewing the reversing of the adverse determination patentability. Term patent shall extend 1 day after each of the date pending for the proceeding order reviewing the case may be. 2 limitations, general extent of the periods of delay attributable to the grounds specified in the paragraph 1 overlap period of new any adjustment granted under the subsection not exceeding the actual number of the day of the issuance of the patent was delayed B. Disclaimed term of no patent term of the which of the disclaim beyond the specified date may be adjusted section of the expiration date specified with the reduction of the period adjustment of the term of the patent within paragraph 1 with the reduce of the period equal to the period of the time during the applicant failed to engage the reasonable effort to conclude prosecution application with respect to the adjustment patent term of the made authority with paragraph 1b with the applicant should be deemed failed to engage reasonable effort to conclude the processing examination application for the cumulative towel a period of time excessive 3 months, aiming to take in the realm of the notes of the office of making any rejection, objection, argument, other requests measuring 3 months period from the day of the notice given and mailed to the application. 3. The director shall prescribe the regulation establishing circumstances the consequence of the failure of the applicant to engage reasonable effort to conclude processing examination application. Procedure of the patent term and adjustable determination. Director shall prescribe the regulation establishing procedure of the application of the determination patent term adjustment under subsection B. Under the procedure established under subparagraph A, the director shall make the determination period of the patent term and adjustable under subsection shall transmit the notice of determination no later to the date of the issuance of the patent to the applicant 1 opportunity with the request of reconsideration any patent term of adjustment determination made by the director. The director shall reinstate all of the part of the cumulative period of time of the adjustment. Paragraph 2. See with the applicant prior of the issuance of the patent showing with in spite of the all due carrier. Applicant was unable to respond with a 3-month period with no case with more than 3 additional months with each such responding beyond the original 3-month year period and reinstated. D. The director proceeding with the grant of the application, completing the director determination, the patent term of the adjustment of the procedure, the establishment of the subsection that was deemed, and the appeal of the take of the applicant such determination. Appeal of the patent with the term and adjustment of the determination. Application for the dissatisfied with the director's decision. Application and request for the reconsideration. Paragraph 3b2 shall have the exclusive remedy for the civil action given the director filed with the United States with the District Court for the Eastern District of Virginia within 100 days after the date of the director's decision. Applicant request for the reconsideration. Chapter 7 and Title 5 shall apply such action with any filing of judgment over the request resulting in a change of the period of the adjustment of the patent term shall be determined by the director. Director shall therefore, after the term of the patent, reflect the such change. The determination of the patent adjustment with the under subsection shall not be subject to the appeal of the challenge of the third party prior to the grant of the patent. Continuation of the termination of the term of the patent and forth of the result of the application filed before the day of the 6 months after the day of the enactment. Ugaria Round Agreement Act shall be grant with the 20-year period provided that subsection A with the 17 year for the grant is subject to the terminal disclaimers. 2. Remedies of section 283, 284, and 285 shall not apply to the acts which was commenced with a substantial investment made with the date with the 6 months after the date of the enactment of the Ugaria Round Agreements Act and become an infringing of the response reason for the paragraph 1 remuneration of the act referred to the paragraph 2 be continued only with the payment of the equitable remuneration patent determined in action brought chapter 28 and 29 other than those provisions excluded in paragraph 2. The provisional rights and with addition of the rights provided in the section of the patent shall include the right to obtain reasonable royalty with a person who during the period become on the day of the publication application such as the patent under subsection 122b. This case an international application filed under a treaty defined in section 35(1)(a) delineating the United States Article 21(2)(a) of such treaty international design application under the treaty defined in section 381(a)(1) designation United States Article under Article 5 such treaty data publication of the application data and ending with the date of the patent issued makes use of the offer sale of the United States with the intention to reclaim the published patent application imports such invention in the United States. 2. The invention is claimed to publish a patent application process offer sale of the United States import of the United States product made in the process claiming the published patent application. Had an actual notice of published patent in the application in the case of the right arising under the paragraph based upon an international application designation United States published a language other than an English translation international application into English law language. 2. Reasonable right based on substantial identical invention right under paragraph 1 with obtain reasonable royalty should not be available under subsection when the invention claimed the patent substantially identical with the inventions claimed in the published patent application. 3. Time limitation pertaining reasonable royalty with the right under paragraph 1 to obtain reasonable royalty available only when the action but no later than 6 years after the patent is issued. The right under paragraph 1 obtainable reasonable royalty shall not be effective for the duration period prescribed in paragraph 1 for requirements for the international application. Effective the right under the paragraph 1 of the reasonable royalty based on the publication of the treaty defined in section 35(1) A. Of the international application designated of the United States shall commence for the day of the publication of the treaty of the international application for the publication of the treaty of the international application for the language other than the English on the day of the patent and trademark office of the receipt of the translation publication in English language. The copy of the director may require for the applicant provide copies of the international application for the translation thereof. Title 35 U.S. Standard Code. Alright, Title 35 U.S. Standard Code 154, Pre-America Inventors Act, Contents Term, Patent, Provisional Rights, Adjustment of the Patent Term, Guarantees, Patentee, Prompt, Patent, Trademark, Offer the Response, subject to the limitation on Paragraph 2, issues original patent delayed due to the failure of the patent trademark. Offer the provide at least one notification under Section 132 with the notice allowance from the Section 151 no later than 14 months after date of which application was filed under Section 111A, the date of the commencement of the national stage of the Section 371 international application. 2. The respondent replied with the Section 132 with the appeal was taken under Section 134 with the 4 months after the date of the reply with the file with the appeal was taken. 3. Application was within 4 months of the date of the decision board patent appeal the interference on Section 134, 135 of the decision federal court under Section 141, 145, 146 in the case allowable the claims remain with the applicant. 4. Issue of the patents 4 months after the date of which issue was paid under Section 151 and all of the outstanding requirements were satisfied with the term of the patent shall extend 1 day after the end of the period specified in clause 1, 2, 3, and 4 as the case until the action described in such clause with a guarantee no more than 3-year application pendency shall be the limitation paragraph 2 of the original patent delay with the failure of the United States patent and trademark off of the patent within 3 years of the actual file within date with the application under Section 11A with the United States within case of the international application date of the commencement. National stage under Section 37(1) of the international application include, but not including the anytime described, consumed, continued examination application required for the application under Section 132B, but the anytime consumed with the proceeding under Section 135 at the time consumed with the imposition order of the Section 181, time consumed with the appeal, it review the board, term patent, and appeal with the interference of federal court. 3. Any delay with the process of the application of the United States patent trademark offer the request for the applicant except the permitted in paragraph 3C with the terms of the patent shall extend 1 day after the end of the 3-year period dated issued, guaranteeing adjustment of the delay due to the interference secrecy or the appeal subject to the limitation on paragraph 2 with the issue of the original patent delayed due to the proceedings under Section 135A, imposition under Section 181. 3. Appeal to review the patent board, appeal interview in federal court in case of which the patent was issued, the diverse determination of the patent. Term of the patent shall be extended 1 day each day of the pendency of the proceeding other further order review in case maybe. Title 35 U.S. Standard Code 155 revealed. Title 35 U.S. Standard Code 155A repealed. Title 35 U.S. Standard Code 156 extension of patent term. The term of the patent for the claim of the methods of the product with the methods of manufacturing products extended in accordance with the section of the original expiration date of the patent, which shall include a patent term adjusted granted in Section 154B with the term of the patent has not expired before the application submitted in subsection D1 extension for the term of the patent never have been extended, or in Section E1 of the Section 3 the application that extends for the submitted original or record of the record of the patent agents according to the requirements of paragraph 1 through 4 of the subsection D. 4. The product has been subject to the regulatory review period before the commercial marketing use. 5A. Except for the provided in paragraph B or C with the permission for the commercial marketing use of the product, such as the regulatory review of the period with the first period of the commercial marketing use of the product under the provisions of the law under the regulatory review period occurred. B. In the case of the patent claim of the method of the manufactured product with the primary use of the recombination DNA technology manufactured product with the permission commercial marketing using the product as the regulatory review period first permitted commercial marketing use of the produced product manufactured on the process claim in the patent. C. Of the purpose of the subparagraph A in the case of the patent in which 1. Claim with the new animal drug with a veterinary and biological product with was not covered in claim with the other patent with the extended with the and 2. With the receipt of the permission of the commercial marketing using non-food producing animal food producing and 2. Was extended on the basis of the regulatory review of the period of the non-food producing animals permission of the commercial marketing use of the drug and the product regulatory review period for use. Food producing animals first permitted commercial marketing use of the drugs and product administration food producing animals. The product referred to in paragraph 4 and 5 herein after should be referred to the approved product, except for the provided in section D5F. The rights derived from the patent term of the which extend under the section of the during of the prior period during which the term of the patent extended. In the case of the patent claims of the limited to the approved of the product before expiration of the term of the patent, and 2, 1, under the provisional law limited to the applicable regulatory review occurred, 2, under provisional laws under which regulatory review described in section paragraphs 1, 4, and 5 are subsection to the G or occurred, B, on or after the expiration of regulatory review period of the extension of the patent was based. 2, in case of the patent was claimed for the method for the use of the product claim limited to the patent and proof of the product. A, before the expiration of the term of the patent under any of the provision of law under the applicable regulatory review occurred. 2, the provision of law under which regulatory review is described in paragraph 1, 4, or 5 of the subsection G or occurred. B, on or after the expiration of regulatory review period for the extension of the period was reviewed, in the case of the patent was claimed the method for the manufactured product with the limited method the manufacturer used to improve the product. For the B, the product has been subject to the regulatory review period described in paragraph 1, 4, or 5. Subsection G, use the subsection of the term product include the approved term of the patent eligible to extend for the subsection A, but it shall extend with the time equal to the regulatory review of the period, improved periodic of the period occurred with the date of the patent is issued, except 1, each period, regulatory review period, review of the period during predetermined with the D2B, but during the applicant with the patent extension did not act with due diligence during such period of the regulatory review period. After reduction in required paragraph 1, when the period extension shall include only one half of the time remaining in the period described in 1B1, 2B1, 3B1, 4B1, 5B1, or subsection G. 3, the period remaining in the term of the patent after the date of the proof of the product with the provision law with the such of the regulatory review occurred with the adding a regulatory review period under the paragraphs 1 and 2 that exceed the 14-year period that extends with the shall be do so that total both such periods does not exceed 14 years. If no event shall be more than 1 point extended with the under subsection E1 same regulatory review period of any product. B, D1, obtaining with the extension of the time of the patent under section owner of the record of the patent, the agent shall submit the application to the director, except as provided in paragraph 5 of the applicant may only be submitted within a 60-day period, beginning with the date of the product receipt of the permission under the provision of law under which the applicable regulatory review the period that occurred with the commercial marketing use of the case of the during drug product, described in subsection 1, the 6-day period beginning of the covered date with the defined subsection 1, the application containing 8 identified with the proof of the product federal statute with which the regulatory review occurred, identified with the patent, the extension of the being solved with identify each claim such patent, which claims to prove the product with the method using of the manufacturer product type. C, the information enable the director to determine the subsection A and B with the eligibility of the patent extension of the rights to derive with the extension of the information enable the director, secretary of the health and human services of the secretary of the agriculture to determine the period of the extension under subsection G. Brief description of the activities undertaken with the application during the applicable regulatory review period with respect to the approved product and the significant dates applicable to such activities. E, patent of the information director may require for the purpose of the date of the product receive the permission under the second sentence of the paragraph each of the permission term transmitted at 4:30 p.m. Eastern Time. Business day transmitted on the day of the non business day product deemed to receive the permission for the next business day for the purpose of the preceding sentence of the term business day means the Monday, Tuesday, Wednesday, Thursday, Friday, excluding legal holiday under section 6103 Title 5. 2A, within 60 days of the submittal of the application extension for the time of the patent on paragraph 1 of the director shall notify the secretary of the agricultural patent claim the drug product method using manufacturing drug product of the drug product used in subject virus serum toxin act. Alright, Secretary of the Health and Human Services of the patent claim that any of the drug product, the medical device, food, the color additive, the method used, the manufacturer of the product device, the additive of the product device, additive subject federal food, drug, cosmetic act, the extension of the application shall submit to the Secretary and notify with a copy of the application no later than 30 days after the receipt of the application. The Director Secretary receipt of the application shall review the date with the containment of the application pursuant to the paragraph 1 C with the determine the applicable regulatory review period. Notify the Director for the determination or publish the Federal Register for the notice of the determination. B1. If the position submitted with the Secretary to make a determination, paragraph A with no later than the 808 day of the publication determination, or in some paragraph A with the reasonably determined of the applicant when they did not with the due diligence to determine the applicable The regulatory review period of the Secretary make with the determination in accordance with the regulation properly gave with the such of the Secretary with the determine the applicant with the action with the due with the diligence determine the applicable regulatory review period. Secretary making the determination shall make the determination no later than 90 days after the receipt of such of the petition with the drug product of the device with the additive subject of the Federal Food, Drug, Cosmetic Act or the Public Health Services Act, with the Secretary may delegate the authority to determination prescribed the clause of the Office of the Director of Food and Drug with further this product or subject versus Serium Toxic Act. Secretary of the Agriculture does not delegate the authority to make the determination prescribed with the clause of the Office of the Below with the Office of the Assistance of Marketing and Inspection Services. Secretary making the determination under the clause and notified with the direction of the determination, public the Federal Register notice of the determination give the factual legal basis over the determination interested person required within 60 day period beginning with the publication of the determination. Secretary making the determination hold the formal hearing of the determination such request made with the such of the period. Secretary hold the such of the hearing no later than 30 days of the day of the request of the person making the request no later than 60 days after the such of the date. Secretary holding the hearing shall provide with the notice of the hearing with the owner of the patent involved with the interested of the person, provide with the owner of the interested person an opportunity to participate in the hearing within 30 days of the completion of the hearing such of the Secretary so affirm a revised determination subject of the hearing shall notify the Director in revision of the determination shall publish in such revision Federal Register. For the purpose of paragraph 2D, B for the duties of the diligence, for the degree of the intention of the continuous directed effort with the timelessness may reasonably be expected for the ordinary exercise of the person during regulatory review period. For application extension of the term of the patent, the subject of the disclosure requirements prescribed by the Director 5A, if the owner required by the record of the patent agent reasonably expect with the applicable the regulatory review period described in paragraphs 8, 1B2, 2B2, and 3B2, and 4B2, and the 5B2 of subsection G with the beginning of the product with the subject of the patent, such patent extended beyond the expiration patent term of the effect of the owner's agent that may submit the application directive with the interim and extension of the during of the period beginning 6 months with the ending with the 15th day with the such of the term to do the exercise of the application contained. Identify with the project shall with the regulatory review the federal statute under which the review the two the identify with the patent such for the interim and extension of the bot so with the identify with each for the claim patent and with the claim of the owner of the product of the regulatory review of method using manufactured product with the 3 of the inform and enable the direct determinant under subsection A1, 2, the 3, and 3 of the eligibility patent extension 4. Brief description of activities undertaken by the applicant during the applicable regulatory review period with the due with the respect of the product under review the significant date with the applicable with such activities and 5 the such patent and the other such other information director may require. B. If the director determines if the accept of the permission of the market for the product of the commercial of the patent would be eligible to extend for the patent term under the section of the director shall publish with the Federal Register of the notice such of the determination including the identity of the product under the regulatory review they shall issue the applicant the certificate in term and extension for the period for no more than 1 year. The owner of the record of the patent of the agents for the interim and extension for the granted on this paragraph B that may not be more than 4 subsequent interim and extension of the paragraph except in the case of the case with the patent subject to the G6C with the owner of the record of the patent agent that may apply with the only one subsequent interim and extension of the paragraph with each of the subsequent application shall be made during the period beginning 60 days before and 30 days before the expiration of the preceding interim extension. D. Each certificate interim extension and number of the paragraph shall be recorded with the official file of the patent shall be considered the original patent. E. The interim extension of the granted number of the paragraph shall terminate end of the 60-day period beginning with the date of the product involved with the receipt of the permission of commercial marketing and the acceptance within 60 days of the applicant notified the director such permission submit with additional information under the paragraph 1 of subsection not previously contained. Application of the interim extension of the patent for the extent of the core of the provision in section for no more than 5 years of the day of the expiration original patent. 2. The patent subject of the subsection G6 C. The day of the which the product was involved with receiving the approval from commercial using rights derived with any of the party patent term of the which extent of the paragraph shall be the during of the period of the interim extension of the case of the patent claim of the product limited to the use of the regulatory review the case of the patent claims method using the product limited to the claim of the patent and with the regulatory review 3 of the case of the patent which claim of the method of production can be limited to the method of manufacturing make the product then under regulatory review. E1, the termination of the patent eligible to extend for the made by the directly sold with the possibility of the representation contained by the application of the extension for the director to determine the patent and the eligible extension under subsection A of the requirement of paragraphs 1 through 4 subsection D have complied with the director shall issue the patent and the application extension for the time when the certificate extension under the shield of the period of the provided prescribed in subsection C certificate shall be recorded official side of the file of the patent shall consume the part of the original patent. 2. If the term patent with the application submitted under subsection D1 and whether expired with a certified extension with the issue with the denied under paragraph 1 with the respecting with the application, the director shall extend until the successful determination is made. Term of the patent periods of the 1 year with the determination of the patent's eligible extension. Alright, for the purpose of this section of the product, meaning with the drug, product with a medical device, food, additive with the color, additive, the subject of the regulation, Federal Food, Drugs, Cosmetic Act, term drug product, meaning with the active, the ingredient with a new drug with the antibiotic drug with a human biological product, or new animal drug with veterinary biological product, and which is not permanently manufactured with the using recombinant DNA, recombinant RNA, hydrobonium technology, other product involving specific genetic manipulation techniques, including salt or ester with the active ingredient, single with the etany with the combination of the ingredient, the term of the major health and environmental effect, with the meaning of the test with the reasonable relate with the evaluation of health and environmental effect of the product with the required with the lease. 6 months with the conduct with the data was submitted with the receipt of the permission commercial marketing with a period analysis evaluation test result with not include with the determination conduct with the test required at least 6 months. 4A the reference to section 351 reference to section 351 public health with the B with the section 503 505 512 or 515 the reference in section 503 505 512 or 515 Federal Food Drug Cosmetic Act the reference to virus serum toxic act reference act of March 4th 1913 term informal hearing, meaning of the prescribed subject terms in Section 201Y of Federal Food Drugs Cosmetic Act. Term of the patent made with the patents issued with the United States Post Patent Trademark over the term of the date with the enactment of the Section September 24th, 1984, the human drug product, the medical device, food additive, the color additive. The term date and enactment of the section with the meaning of the date with the enactment of generic animal drug with the patent term administration with the animal drug with a veterinary and biological product. For the purpose of this section, regulatory review period of the following means 1A with the case of the product with the new drug with the antibiotic human biological product with the term they mean with the period described in paragraph B with limitations described in paragraph 6 apply with the regulatory review period with the new drug with the antibiotic drug with the human biological product the period beginning on the date of the exemption or subsection section 505 subsection D with the section 507 and effective with the proof of the product with the ending with the date of the application initially submitted with respect to the drug product or in section 351 505 or 507 and ending of the date of such application was approved under such section. 2. In the case of the product of the food additive with the color additive with the term mean with the prescribed with the subparagraph B limitation described in the paragraph 6 of the regulatory review period of the food color additive sum of the period beginning with the date of the major health environmental test of the additive that was initiated, ending with the date of the position initially submitted with respect to the product of the Federal Food Drug with the Cosmetic Act with the issue with the regulation with the product. 2. The period beginning with the date of the petition initially submitted with the respect of the product on the Federal Food Drug the Cosmetic Act with the requesting issue with the regulation of the product ending with the date with the respect of the regulation became in effect with the objections filed with the respect of the regulation ending with the date of the respect of the objection the result of the commercial marketing was permitted or the commercial marketing was permitted later revoked pending in the further proceeding of the result of the objection the ending with the date with the respect of the proceeding filed and the result of the commercial marketing was permitted. 3A with the case of the product of the medical device, the terms mean with the period with the described in the paragraph with the B with limitations described in the paragraph 6 of B with the regulatory review period with the medical device and some of the period beginning date of clinical investigation human involved with the device with the beginning ending with the date of the application initially submitted with the respect of the device under the section 515 with the period beginning with the day application initially submitted with respect with the device under the section 515 and ending with the date of such application approved under such act with the period beginning with the day with the notice of the completion of the product development protocol was initially submitted under section 515 F1 ended with the protocol was declared completed under section 515 in F6 and 4 in the case of the product of the new animal drug with the term and they prescribed as in the subparagraph B with the limitations described in paragraph 6 with the regulatory review period with the new animal product. Some of the period of beginning with the earlier of the major health and environmental facts of the testing with the drug initiated with the data examination on the subsection J of section 512 becoming effective with the proof of the new animal drug with the product and ending when the date of the application was initially submitted with the type of the animal drug product or in section 512 with the new beginning with the date of the application initially submitted with the proof of the animal drug product subsection B, section 512, and ending with the date of the application approved within the section. Indicate for the product of which veterinary biological product will determine the period of the described in subparagraph B with limitations described in paragraph 6 of the regulatory period of the veterinary biological product in some period beginning with the date of the authority prior to the environmental biological product under Virus Serum Toxin Act, effective and ending with the date of the application life and then submitted with the Virus Serum Toxic Act. Period beginning with the date of the application life and then initially submitted with the approval of the Virus Serum Toxin Act and ended in such with the license for the period of the day, seek for the period determining under the preceding paragraph subject to the following limitation. A, with the patent involved the issue after the date of the enactment in section with describe the extension determine the base regulatory review period determine any subparagraph with not exceeding 5 years. If the patent involved was issued for the date of the enactment in section with no request of exemption described in paragraph 1B or 4B submitted with the request of the authority described in 5B was submitted. 2, with no major health environmental effect of that test described in paragraph 2B and 4 or 4B with initiated no petition regulation application for the registration described in such paragraph submitted. 3, no clinical investigation described in paragraph 3 with the begun product development protocol described in the paragraph submitted before such the date of the proof of the product with the period extension determined on the basis of the regulatory review of the period determined under any such paragraph within the exceeding 5 years. C, with the patent involved with the issue before the date of the enactment section with the action with the described in the subparagraph that you with the take with the date of the enactment and the section with the respect with the approved product with the commercial marketing you with the product with the not been approved with the date with the period extended for determine the base of the regulatory review period determined under the of the paragraph not exceeding 2 years in the case of an improved product with a new animal drug with a veterinary and biological product with also determine the federal food with the drug, the domestic act, and cosmetic act with the Virus Serum Toxin Act 3 years. The director must establish such fees if the director determine appropriate to cover the cost of the office of the receiving and acting upon applications under the section 1I1. For the purpose of this section, Secretary of the Health, the Human Services provides no for the sponsor of any application request approval of the conditional approval of the inducing drug product with the Secretary intended to recommend controls and when the Controlled Substance Act at the beginning when the cover date of the drug or product will be considered. Having been approved with an index of the relevant provision of Public Health Services Act and the Federal Food, Drug, and Cosmetic Act, have the permission corresponding marketing use in subsection with the covered date with the date of the application approved under section 35(1)(a)(2)(c) with the Public Service Act under section 505(b) and 512 or 512(c) with the Federal Food, Drug, Cosmetic Act. The date of the application is continued and additionally approved with under section 571 Federal Food, Drug, Cosmetic Act. The date of the request of the index and granted under 572 Federal Drug, Cosmetic Act. The date issued with the interim final rule controlling drug under section 201J Controlled Substance Act. Alright, 35 U.S. Standard Code 157 repealed. Title 35 U.S. Standard Code 157 Pre-American Invention Act, Statutory Invention Registration. Nothing withstands any other provision of the Director of the authorized published statutory invention registration containing specification, drawings, regulatory file, application, patent examination, if the applicable application meets requirements section 112, comply with requirements pertaining to the fourth regulation, the Director waive the right to receive the patent over the invention such period with the prescribed by the Director for the pay application, publication, and other processing fees established by the Director. If any interference declared with the respect for the application subject to statutory invention registration published unless the issue for the priority of the invention was finally determined in favor of the application. 8th, the waiver under subsection A3 with the action of the application to take effect for the publication statutory invention registration. Statutory invention with the registration published from pursuant to the section have they attributed to specified with the patent with the title except for those specified in 183 section 271 through 289. Statutory invention registration shall not have any attributed for the specified with the patents any of the provision law of the other than the type of the statutory invention registration published pursuant to the section shall give appropriate notice to the public pursuant to the regulation of the Director shall issue the preceding provisions of the subsection invention with respect to the statutory invention certificate published for the patent invention for the purpose of section 292. The Director shall report with the Congress annually the use of the statutory invention regulation shall report with the include the assessment of the degree with which the agency federal government making use of the statutory invention regulatory system degree which aids the management of the federally developed technology assessment of its cost with the federal government use of such procedure. Chapter 15 Plant Patents.